We are streaming live on YouTube. Yay!
All right.
So this is Jennifer Hammond. I'm so excited because we have Will Andersen from the Andersen firm here to talk to us all about, number one, we're going to start with the 3 biggest mistakes that people make with estate planning. And of course, with estate planning, this is one of those things nobody likes to talk about death. And certainly those mistakes, when you make those mistakes after someone dies, it's not like you can go back. You know, there's so many other things in life where you can go back and go, okay, let's do a do-over. But with estate planning, you know, that death thing, it's kind of final, right?
That's exactly right. Good morning, Jennifer. Thanks for having me on today. And no, you're exactly right. And, look, this is not the most exciting area of law. There's no gunshots and explosions. They don't make movies about the estate planner, but it's really important. And so today I'm going to go over a few topics, biggest mistakes first, but we're going to have some stories in there, people that listeners may know that maybe they don't know the whole story. But at the end of the day, just to go ahead and kick it off, the 3 biggest mistakes, I'd say one you could put in bold letters, and that's using a will. Now, my corny joke is that I'm the only correct will in estate planning, Will Andersen. Look, I know that's bad. I don't get a lot of good ones.
But I do think it's funny that you went into wills, being that your name is Will. I mean, my dad and I were talking about you, and we said, well, at least he's living up to his name, right?
Exactly right. Exactly right. So, my father was an estate planner too. So whether that was intentional or not, who knows? But at the end of the day, using a will is easily the biggest mistake that people can make. A lot of people don't realize that a will is really your ticket into court. It's your ticket into probate court. And that is not an ideal situation for most people. If you've ever dealt...
So I was going to say, let's talk about that. I don't know if you can give an example of, I know because of real estate, probate, and going into court and waiting for the courts to decide on any aspect of a will is just incredibly time consuming, frustrating. So do you have any examples you could share on why
100%.
You don't want to do probate?
Oh, 100%. I mean, look, it's the short is it's time consuming, it's expensive, and it's public. All 3 things are completely avoidable. But I think a perfect example is the Prince estate. Remember Prince, singer, Purple Rain, all that good stuff.
If I could sing a tune, I'd sing one.
That's
right.
Now. Well, Prince, I think his estate clocked in at about $500 million, but Prince never wanted to think about death. He never did any sort of planning whatsoever. And if you don't have anything or you just die with a will, you're going to probate. And of course, it's a public proceeding. And so everyone, all of a sudden, everyone is a child of Prince, and you've got people wanting to come and get DNA tests and trying to get involved. That estate is still open. It is something that we're years and years down the line. But you've just now started hearing Prince's songs being used in ads that Prince would never have allowed to happen had he done any planning whatsoever. So when you see a Tide commercial with Prince on it, you know that he's not the one that got to control what happened with his music. And instead, the court runs it through to the closest living relatives that he wasn't close to. He had no control over the situation. Now, that's really not using any planning at all. But when we die with a will, it's very similar, and except for the fact that you have told the court, here's the people I want you to use as your hands. That executor function a lot of people think of. The executor is not really the person who's going to go and do all of the things that you asked them to do. The court is going to do that. So at the end of the day, the court is going to use your executor as their hands, and they're going to try to put effect to what you have in your documents. But you're looking at years in some cases. And so I'll give you a really good example from my practice of a situation where we had a lady who had not updated her documents in 20 years. And we got a call from her financial advisor saying she's in hospice. I don't know how long we have left. Can you go help her? We got in there and we did we created a trust-based plan for her, and we executed it. I mean, on Thanksgiving morning, I had my in-laws as the witnesses on that one. There, we didn't have the rest of the firm, obviously, but at the end of the day, for the stuff that got put into the trust, the family had access to it immediately. For everything else, the investment advisor was the only person who was able to get the assets retitled, so put into the trust. Everything else was going through probate. This was in 2016. We haven't heard really anything about the investment account or thought about it since then because they just got immediate access to it. The probate is still open.
Oh, that's not good.
No. So, that's a major one. And, I'll say this, that a lot of attorneys, this is something that people need to watch out for. They call using a will, the estate planner's retirement plan. You do a will for people and then you wait for your client to mature. And so when they pass, you're going to collect this giant fee for this giant probate that you're going to have to end up settling. So that's great for the attorney, but that's not so good for the client. And right. So, that's there's no love lost here between attorneys that do that and myself. But that's why the first thing that we do for somebody is get them in a trust-based plan to avoid the court process altogether.
And so let's define that, Will, because one of the things, and it's so funny to call you Will doesn't believe in wills, believe in a trust-based plan. So what does that mean? Define that.
So any good estate plan, and I don't care if you have $100,000 or $100 million, it is based around a revocable living trust. Now, a lot of people call that a will substitute or a will replacement. And it's technically right, but it can do a lot more than what a will can do, which I'll get into shortly. But in effect, when we create one of these revocable living trusts, it doesn't change the way you live your life at all. You still swipe your card at the grocery. You still swipe your card for Disney. It doesn't change any of that. It should only change the name on your bank statement. But by putting assets into a revocable living trust, and if you do it right, you're going to put everything in there. If you get that done, then we essentially get to tell the court thanks, but no thanks. We're handling this privately. And so since we're handling the settlement of the estate privately without needing the court to rubber stamp getting rid of that timeshare we got suckered into buying, at that point, we can settle a trust in a month and a half, 2 months. I mean, if everything gets funded into the trust, we give the court a piece of paper that says, look, we're handling this privately. If anybody wants to sue Jennifer's estate, if anybody wants to say Jennifer owed me money, then at that point, they can come talk to this trustee. Other than that, have a nice day. And so because we're settling it so fast and we don't need to have a court involvement, we can do it for a fraction of the price. You're looking at saving your beneficiaries a ton of money, a ton of heartache. It's just a better mousetrap.
Wow. It's so interesting because, again, it's not what I think most people understand, which again is why I wanted to go over what are the 3 biggest mistakes that people make, because again, like I said at the top of the hour, people don't like to talk about death. And this is one of those things that if you don't confront this uncomfortable topic, there's not a do-over once someone has passed away.
Right.
And it's just so important to go ahead and see what your options are. So I think probably one of the questions that right off the bat that I have had a lot of my clients in real estate ask about is, so what if I'm not rich? That whole thing about having a trust, that's really for the rich people, right?
That is a good point, and that's what a lot of people think. But at the end of the day, your money is your money, and you want to make sure that it gets passed down to your family correctly. And especially to make sure that a lawyer is not going to take a giant chunk out of their inheritance. But for the client themselves, everything I'm talking about right now is making your kids' lives easier. Some people say, I'm gone. What do I care? What about for you while you're alive? Well, that revocable living trust-based plan that I spoke about a second ago, it can do things that a will simply can't do. And for that client that does have $100,000, $200,000, whatever it may be, how about your mental disability while you're alive? Do you want to take control of that? do you want a court making the decision that you're disabled? Well, I prefer, instead of having to run a guardianship proceeding because you're doing something like, and this is a real thing we had happen, like paying every single piece of mail that comes to your house, thinking that it's a bill. Who's there to say that's not right? Jennifer wouldn't be doing that if she was in her right mind. Well, if we don't have any documents in place, and Will can't do this for you, then you're going to be going through a guardianship proceeding. Somebody's going to be there. A court's going to appoint doctors to look at you. If they determine that you're disabled, then at that point, if you have no documents, they're also going to appoint who handles your finances now. But that I don't like that scenario for a few reasons. One, there's not a single person in that process that knows you. Second, if we go that route, it's a court proceeding, and it's an expensive one that you get the pleasure of paying for. And frankly, I don't want to be brought in front of a court to prove I'm crazy.
Or not crazy. I mean, it looks exactly like the absence of, how do you define crazy? Because
that's right.
If you looked at some really rich people, I'm sure you could define some of their behavior as maybe odd. And is that crazy, or is that just eccentric? Or
I've got a serious story for you about that here in just a second. Everybody knows
good.
This guy. But first, I prefer to use what's called a disability panel. And that's something that we can only do in a revocable living trust. And so this is a person, or it's a group of people that's chosen by you, that if they determine that you are disabled and that you shouldn't be in control of your own finances, along with your primary care physician — I don't want anybody getting mad at you and declaring you disabled. I want a medical license on the line. But if that was to happen, then now you get a signature from the person you chose and your doctor. And now we've accomplished in one day, privately, with no court proceeding whatsoever, I guess the cost of the doctor's appointment and the document. But at that point, now we've accomplished in one day what it would otherwise take weeks in a court proceeding to accomplish. So, we've done it privately to boot. Now, here is another one of the biggest mistakes that people make, and it is related back to this, I promise, that people make, is they think all trusts are created equal. And anybody who has a trust currently out there, go look at your disability provisions. If you see licensed physician, in the opinion of two licensed physicians, that drives me insane. Because look, you can find a physician to say whatever you want if you look hard enough. And look, the lawyers are not exempt from that either. If you look hard enough, you can find a lawyer to say what you want too. That's why we have to say, I want this doctor. That way it is a lot harder to doctor shop when we have a specified doctor, at least the primary care. And I'll give you a good story about this. Do you remember Donald Sterling? He was the coach of the Clippers, who got caught saying all that racist stuff to his girlfriend. Anyway, his wife was none too happy about the conversation that his girlfriend had recorded. And so this was in California. They had estate planning done. They had a trust-based plan done, but it didn't specify the doctors that were necessary in order to activate his disability panel. And it just said, 3 licensed physicians or something of that nature. Well, she had these doctors come over, evaluate him at the house when he didn't know that that's what he was being evaluated for. They signed off on the disability panel that he couldn't handle a trust of that size. Very, very interesting caveat that was thrown in there. But the real drop the mic moment, so to speak, of this was she made a deal with Steve Ballmer, the CEO of Microsoft, to buy the team for, I think, $2 billion. It was the largest sale in the history of the NBA at the time. But when this happened, she needed his signature too in order to sell the team. Well, at the meeting, he says, absolutely not. There's nothing you can do. I will not sign this document. You know what you can do. And so the wife pulls out the document, the disability panel. She was the last signature on it, signed her name on that certificate of incapacity, and sold the team out from under him for $2 billion.
Oh my gosh. I did not know that story.
They're still married, by the way.
Oh.
So, not all documents are created equal. It's important that, you find the right balance and that you don't just say, well, this is standard language. Everybody has it. Standard language doesn't mean good language. So that's another big thing that people do. They think all trust.
That's I like that one. It's just I was just going to say, I think that's such a great saying. All standard language is not always good language. Because as you know, in real estate, because I know you've dealt with a lot of real estate and contracts over the years, not all standard language in a real estate contract is necessarily good language or is good for you, regardless of whether you're the buyer or the seller in real estate contracts. But I've just seen it so often. The standard language was whatever, a bunch of lawyers that got together and kind of generically came up with standard language. And that is not the best for you. So I think that's a really good principle to make sure you're aware of.
And I'll actually review documents and I can tell the age of the attorney that drafted it based on the language that's being used. I mean, look, if you ever see party of the first part run, okay, that's not standard anymore. But also, there's this common scheme of I want to leave a third to my kids at 30, a third at 35, a third at 40. And I bet a bunch of your listeners have that in their documents right now. Do not do that. When you do something of that nature, every time that they hit that age, it gets distributed out to them in their own name. And now what are they going to do? What do you do when you get a check in your own name? You put it in your checking account. Of course.
Yeah, right.
Well, now creditors, predators, divorcing spouses, lawsuits, all of those people can attack that money. And that's crazy. It makes me pull my hair out. Don't do that. Don't let the money just fall out of the proverbial safe. What we prefer to do is say, look, you're going to have some help from a trustee. That when you decide that you want to be the coolest kid on campus and show up freshman year with a Ferrari, you're going to have to go talk to the trustee. And he's there to say, absolutely not with your parents' money, you're not. But here's 30, go to Nissan. But then at a certain age, instead of just giving the kid the money, why don't you give them the combination to the safe? Why not give them the keys to the kingdom? Make them their own trustee. And then they get to keep that asset protection, all those asset protection benefits you've given them, and they'll have that full control. So, it's a no-brainer. But you still see it coming in because sometimes people don't update their process. They don't learn. That's why I call it the practice of law. You're never done learning.
Yeah, I would say practice. That's a good way. You can practice over and over and over. Practice makes perfect. But just like real estate, I know with what you do, in estate planning, it's always changing because one thing I know, I don't want to go too far down a little bunny trail, but one thing that is really interesting is that it really is there are different layers because there's federal laws, there's state laws, and then of course, whatever your specific situation is. And it's different layers and it's constantly changing, right?
That's exactly right. It is a moving target. And there's certain things that you can say, well, this is probably going to stick around for a while. But then there's certain things like the estate tax that as soon as we have a new administration, as soon as we have a political shift, and I'm not here to talk politics, I'm like Joe Friday, just the facts. When we have a shift at that point, it's very probable that there's going to be a change in the tax law, especially if they're controlling all three chambers. If you've got the Senate, you've got the House, you've got the presidency, then at that point, that's when you get a new tax plan. So, just because you don't have an estate tax today, and this is, if you had a little siren, I'd say hit it right now. That's right. But, a lot of people think, oh, right now the estate tax exemption is $11.7 million per person. Well, that doesn't affect me. But what they didn't hear was the rest of the story. If nothing changes in our tax law, that's dropping back down to 5.5 million index for inflation. So, that's legalese for roughly 6 million-ish in 2025. And that's just around the corner. But there are currently proposals running their way through Congress right now that would drop that number down to $3.5 million per person and drop the lifetime gifting that you can do, that you can give away during your lifetime, down to $1 million. So it's really important that you get proper estate planning done today, especially with as high of an exemption amount as we have right now. At this point, we can still do things with it. We can use it today by using certain strategies where we can gift that money out, and now you're grandfathered in. When they try to come back and say, well, it's down to $1 million now, we say we're not worried about that because we gifted it out when we had 11.7. But we don't worry. When I say gift, I'm not saying that you necessarily have to lose control or give it to your kids now, but you use that principle. So. Now,
right. And I was going to say, so let's do a quick review. So we're talking first about the 3 biggest mistakes that people make when creating estate planning. And again, they don't like talking about death. So this always becomes a really touchy one. But also we're going to dive in deeper with some more stories about why you should do that estate planning early and not be waiting. I think, last year in 2020 with the pandemic, a lot of people started confronting estate planning that they had never had before. But number 3, we're also going to talk about why you should not gift away your family home. So let's start again with those three biggest mistakes. Number 1, even though your name is Will Andersen.
That's right. Using a last will and testament. Using this will's okay. I'm sorry, I can't stop. First is using a will. Second is all trusts are not created equal. Don't think that just because you have a trust, this little 16, 19 page trust, that you think it's acceptable. I review documents for free, and I do that because when I see that 19 page document come across my desk, I'm going to send you a breakdown of the things that are wrong with it. But at the end of the day, your trust is not the same as my trust. And so you got to make sure that you have one that is well done and appropriate. And number 3, and this is a big one for the people that do have trusts, is not funding it. Creating a trust and then not putting everything you have in it it's probably the most common mistake that you see from clients that do have a trust-based plan. And so, and actually, a lot of times it's not even the client's fault. I've seen a lot of documents come across my desk along with this little funding sheet that the law firm gave out. And it is this generic funding sheet saying you may want to put your checking accounts in, you may want to put your real estate in. And what they've done is they've done just enough to avoid a malpractice action from your beneficiary. So they can say, oh, no, I told them to fund it. See, look at the sheet. But that's not, it's just disingenuous. And so you need to make sure that everything you have that can be owned by a trust, which for all intents and purposes is everything but your retirement plans, everything should be in that trust. And that way you avoid probate. But these attorneys will do this because now they get to settle a trust and a probate. And I just had somebody come into the office in the last 2 weeks that said, I think the only thing that's in my trust is the house, and that's it. And it was, well, what about everything else? They said, they never said that I needed to do that. So, it's one of these things. Make sure that you're funding it properly. Save your kids the headache.
Yeah, it's so important. I think that, again, this is why I was so passionate and why we're doing a whole series. This is on YouTube and we're streaming into Clubhouse, but I have some questions I know from the Clubhouse folks, and we do have Linda DeMarlar. She's our tax expert, and I know she has 1 or 2 questions for you as well. But before we go there, I want to make sure people know that you are going to do a whole series with me. So definitely tune into the podcast. We have some amazing topics that are coming up. I think it's going to be amazing. I want to go ahead and go through a couple. So the spousal lifetime access trust. I can't wait to talk about that. The 7 mandatory components for a good foundation of any estate plan. And again, that is not just, so often people think their whole estate plan is just a will or anyway, we'll go into that deeper. Then we have another show that is where you live matters and establishing that domicile. And then number two, that qualified personal residence trust. That's a really important one. And then we have another show. And of course, each one of these goes into much more detail. The asset protection for your personal resident, asset protection for an investment property, because of course, you know, I love real estate. And then do you really need to retitle the home when you have a trust? So we're going to keep on going into all sorts of topics. I just wanted to give a quick little preview of some of the topics we're going to talk about. So today we've been talking about those three biggest mistakes. And now I wanted to, we're going to open it up in a little bit for questions. So you guys remember, I know John has questions, Linda has questions, and some other questions from the audience as well. But I want to make sure that we finish promising, or finish fulfilling the promise that we said. So why should you do the planning early? I love that you use the example of celebrities. You use Prince in the beginning, but let's talk about about why is it important to do your estate planning early?
So it's a really good question. Like you said, this is something that people don't like to think about, and they think, "Oh, I'm in my 30s, I'm in my 40s, I'm in my 50s. I don't need to do that yet." And there's a couple of really big reasons. One is you never know when you're going to go. Look, Prince didn't think he was going to go either, but then he died with nothing. But then, I'll use Philip Seymour Hoffman as a really good example of somebody who they did the most basic planning a person could do. They had a will, but Philip Seymour Hoffman, I believe, did his last update to his documents when he was 20. And so he was just somebody starting out at that point. And he left everything to his girlfriend at the time. Now, if he had spoken to an estate planning attorney, one of the things that he certainly would have heard is, why are you not getting married? Is there a good reason that you're not getting married? Because at the end of the day, he had a child with the woman, and they were life partners for all intents and purposes. But when he died, that will simply said everything goes to my significant other and then down to my daughter. Now, that's pretty standard. Of course, that's what you would think it would say. The problem is Philip Seymour Hoffman had a taxable estate. And so when he passed, there was an estate tax due and payable when everything went to his significant other, the mother of his child. And so they owed a big estate tax right then. If they had gotten married, then he would have first deferred any tax that would have been due until after her death. But he would have also gotten to use her exemption amount. Meaning, I talked about that 11.7 right now. It wasn't that high at this point. But for number's sake, if you got 11 million bucks and your wife has 11 million bucks, then now together you can pass 22 million bucks without being assessed an estate tax. But instead, he got an estate tax assessed right there on the transfer to his significant other. Now, for the daughter, think about what's going to happen when mom passes. It's going to happen again. And now that money is going to be hit twice with two different estate taxes.
So the same money gets double taxed just with the estate tax, not with the other. It's just because they didn't do estate planning.
You got it. You got it. And it's unnecessary. It doesn't need, and look, if you're George Steinbrenner and you plan everything perfect, the owner of the Yankees, he died in the year that there was no estate tax, which a lot of people say is the only reason that the family was able to keep the team without having to sell off assets. But look, most of us aren't George Steinbrenner, and there's nothing on the horizon that would indicate we're going to be in a place where with no estate tax anywhere in the near future. So.
Well, and I think that's one thing that's really important is just understanding the basics of the estate tax and how many different ways that can affect a person. Because again, it's something that people don't like to talk about. And just like life insurance, I found that so many people don't like to talk about life insurance because again, it's all revolving around this really uncomfortable thing, death. And what does that mean? And I'd say three things: death, money, and taxes. Three things that people shy away from talking about, which is, again, why I was so excited to have you talk.
Well, I appreciate you having me. And, with insurance, it's its own special animal because you've got, unfortunately, a lot of people who are just trying to sell you life insurance for the sake of getting the commission. And that's fine, I suppose, if that's your career. But unfortunately, it makes it so that a lot of people get turned off the second they hear the words life insurance. They think you're just trying to get me. You're just trying to sell me something I don't need. And so it makes it harder when we have legitimate uses for life insurance for estate planning purposes and buy sell agreements. If you have partners in a business, it just makes it a lot harder for the people that are trying to give it to you for good reason. I do teach continuing education for CFPs and certified financial planners, and for people's insurance licenses. But I don't sell insurance. I never have, never will, because that's the way I keep a little bit of credibility here. I say, look, this is something you need. I'm not going to sell it to you. You go find somebody else that can do that for you. But it's a shame. But life insurance is not always bad. The last thing I'll say on that is, by the way, yes, it's good for estate planning, but it shouldn't be your whole estate plan. There's sometimes some attorneys get very lazy, and maybe they have a good friend who does sell insurance, and the bigger the policy, the bigger their commission. It should be a tool in the tool belt after we've squeezed your estate down as far as we can. We solve the rest of the problem with insurance, but.
Well, and I was going to say, and I definitely want to dive in deep on a different episode on that, because there are so many questions there. I think the interesting part is one of the people who is participating and about to ask you questions is Linda DeMarlar, and she's our tax expert and speaker. And ironically, you and her share that same thing, that passion for teaching, to the point where she also teaches not only attorneys, but also real estate agents, all of our continuing, well, not all, but some of our continuing education classes, of course, specializing for her in the taxes. And she loves to find, just like you, she shares great stories. She works a lot of celebrities, and it's been really fun. So I will open up to the questions. And Linda, if you could just give us like 5 minutes. I wanted to finish before the one thing that we also said, we talked about the three biggest mistakes. We talked about why you should do your estate planning early, and we can expand a little bit more on that. But number 3, I want to make sure we finish this topic as well, is why should you not gift away your family home?
I bet Linda is bouncing around in her seat right now because she
is. I can tell. I promise, Linda, you'll be next.
No. The reason is the answer to that question. She knows the answer to this question, and it's called the step up in basis. This is the thing that drives me nuts. It makes me want to pull my hair out when people say, I'm getting older. I'd love to see the kids enjoy the home. I'd like to just gift them the house. And that is such a noble reason. And I understand it. I get it. But when you do that, when you gift that home, you're also gifting them your basis. Now, if you're curious what the basis is, if you buy your home for $200,000 and you sell it for $300,000, then you're going to owe capital gains tax on that $100,000 difference. Well, you have this golden opportunity when you pass with the home, when you pass with any piece of property, but especially the home, that you get what's called a step up in basis, which is legalese for now when your kids go sell the house, their basis is the date of death value. So guys, if you have a parent pass and the attorney suggests you get a valuation done as of the date of death, do it. Don't be cheap. Come on. You're gonna spend a lot more money in taxes than you would on that valuation or on that appraisal. So that's why I think Linda, she knew the answer to that one.
Well, for sure. And I was going to say, and that's something I think that is so important, is to understand again that thing, because I have clients right now who have had that. Their parents bought property in the Arlington, Virginia area, and they have 3 children. And so the nice part was they didn't do anything. They did utilize trusts. Yay! And they didn't transfer anything prior. And that was for investment property as well as their own personal home. But let's go ahead, and I want to go ahead and start asking. So Linda, do you want to go ahead? And I know you had some questions for our attorney.
Yes, I have 2 things that I wanted to tell Will, and he'll want to use these the next time he does a speech or something, because this is how I use the example to scare people. I have a client, actually, she's also a dear friend, and her 25-year-old son went on a skiing vacation, and unfortunately, during the drive out there, was killed by a drunk driver. Okay, she had supported that child since age 2. The ex-husband had never done anything, and for about 5 years, it took to sue the people who were in the car who caused the accident. And there was a multi-million-dollar settlement that eventually came about. But guess who got half the money? Can you guess? The father, who had never paid for the kid for not for anything, not for schooling, not for college, not for law school, not for anything, because the little boy didn't have a will. So who inherits? Well, his parents, because he didn't have any brothers or sisters. So I mean, she lost her son, and the money could never make up for it. But the fact that she had to lose her son, go through 5 years of litigation, and finally collect the money, and of course pay the lawyers, and then split it with an ex-husband who was, oh my gosh, of course, I think he died a couple of years later from all the drugs he kept overdoing. Mm-hmm. So there's one thing. And I tell people the main reason, not just the stepped up basis, because sometimes they don't understand that. The main reason is you never gift anything except if you want to help your children with down payments on cars or even down payments on houses. And I've done that because I have 3 wonderful children. But the reason that you don't give away your money or your house or your assets before you die is because you will get more visits in the nursing home if you if you stay in control of your money. Now, of course, I've already got a wonderful revocable living trust will, or whatever you want to call it. And I love your name, Will, by the way. And because I own my own company, Tax Masters, and my son now runs the company, so I'm semi-retired except for doing public appearances and things. And he's going to inherit the company when I pass. So my house is going to go, I think it's 45% to each of my 2 daughters, one of whom is a lawyer, and she's in charge of my trust anyway. And so my daughters each get 45%, which ends up being 90. And my son will only get 10% of my house because he's already getting the company. Now, I have many times when my clients, they have children who have different kinds of income. My children's income is all very the same, so there's no jealousy. But many times, they'll have, for instance, I have a client, she's got 2 sons that are very wealthy lawyers, and she has a daughter who's wonderful, who takes care of the mother, drives her to all of her doctor appointments, and she's just a little teacher, and she'll never, ever make the money that the 2 sons who live out here in Potomac, Maryland, and, they make hundreds of thousands of dollars, both of them. So but she doesn't want the children to know, first of all, who's getting what. So in her revocable living trust, it's divided up. But since her lawyer, and also she's named me as her executor, a lot of my clients have done that in the past, although now I encourage them to use my daughter because she's younger. But you have things that you want to leave to your children in different proportions. So you could mention that also, that your will is a secret. I think, wasn't it Jackie Kennedy who made the mistake of not having a revocable living trust where everything wasn't kept a secret? So if you want to leave money disproportionately or something like that, I recommend them. So those are, I guess, the 3 things I wanted to mention. And feel free to incorporate those in your speeches, Will.
That's great.
Everybody who says they're too young for a will, no, you are never too young. I made my children get wills by the time they were 20, 21 years old, especially when my son, oh my gosh, he surprised me. And during college, just before he went to law school, he joined the Air Force Reserves. And of course, they called him up and he got sent to the war zone. And of course, they encouraged him to have a will. And he said, I already have a will because my mother made me get one.
That's fantastic.
Managing my company. But that you're never too young to have a will. So I'm whatever John says, whatever Will says, I'm behind it 100%. And thank you, Will. This is a wonderful show. I hope you'll come back. This is Lynn, over and out.
Thanks, Linda. I really appreciate the words, and I'm just so happy that I got a chance to be here. And you nailed it. For disproportionate inheritances and things of that nature. Yes, we want the privacy of the document. I'll piggyback and go even a step further with that. Look, this isn't even the legal side. This is the family harmony side. Talk to your kids before you die about what it says in your estate plan. And I'm not even talking about just disproportionate inheritances. That's a big one, because when they find out and the lawyer that's talking to them is the first time that they're hearing about it, well, you could have headed that off at the pass while you were still alive. But now it's going to be their problem. And now we may get into estate litigation and things of that nature. But this is something for everyone. I see more estates blow apart over the stuff than I do over the money any day of the week. I can cut an account in however many ways you want. I can't cut your watch in half. I can't cut your necklace in half. So talk to the kids, get them all in the same room and say, guys, I'm doing some estate planning. What's important to you that I have? I'm not going to have this conversation with you all independently. I don't want there to be a mom told me this, mom told me that. We're only going to discuss this as a family. But guys, what's important to you? And that in and of itself can oftentimes help the family cohesion after you're gone. So I throw that out there. You're exactly right. On point, Linda.
Well, and I was going to say, I love the fact that, it's so important to understand that there are different layers to this. There's the legal layer, and of course, there's the tax layer. But then, as you were just saying, there's also just the family harmony, the family dynamics, and communication is really key in this. Again, I know it's a huge confront to confront the subject of death, but it's so important that we talk about it early. And so you had talked about in the beginning the difference between, so I want to go back to some basics before we run out of time. What is the difference, and how will you do some defining? Because again, so often as real estate, I have so many legal terms. You obviously a lawyer, you have a bunch of legal terms. So define the difference between a will and a trust and the different kinds of trust there are.
Sure. So first, a will is probably the colloquial term that we all use. You hear it in the media. It is you saying what you want to have happen to your stuff. Yes. But at the end of the day, this is what people have used for centuries to leave their stuff, but it goes through the court process. A trust is simply a vehicle that we put our assets into, and you dictate what you want to have happen to them privately. That's why people call it a will replacement. Now, Jeffrey said, tell me about the different kinds of trust. That's a little bit like saying, tell me about the different kinds of sauce. Well, there's a lot, but I understand what you're saying. It's like sauce. There's a red sauce and a white sauce. There is revocable trust and there's irrevocable trust. And these generally talk about how much control you're having to give up. If you are the trustee, you're the trust maker, you're the beneficiary, that means you're the king or queen of your respective castle. You can do whatever the heck you want with it. Now, it doesn't provide you any sort of asset protection. If you want asset protection, then generally there's going to be you giving up some part of that. You're going to give up being the trustee. You're going to give up being the beneficiary. But that could be okay. Maybe you're looking to gift this money out now. Well, let's put it in a trust for the kids. I don't know if I'm going to be, I may not want to give it to them right this second, but I know in the future, my kids are the only ones I plan on gifting to. So maybe I gift it into what we call a legacy trust or a gifting trust for the kids. But, there is so much that you can do. It's like I described trust law like football a little bit. And by that, I mean, if you don't know anything about it, if you're from Europe and you come over here and you try to watch a football game, you're going to be lost at first. But then all of a sudden,